Mr. Busuttil.
My Lords, the overarching point I was making in respect of the appellant's note was that the predicate of that note is that the Section 3 tort remains a tort of which financial loss is the gist of the action, and what I'm seeking to persuade you of is that that is not right, and what Parliament did by Section 3 was create a tort actionable per se.
Well, that's what most of the argument in the case is about, but the point made in the appellant's note, which is what I was expecting you to be addressing, was that the section doesn't say anything about what the defendant may or may not prove. All it says is what the plaintiff would need to prove. And the point they're making is that at best that would create a rebuttable presumption because it doesn't stop the defendant from proving that no pecuniary loss was suffered. Well, that's the point in their note.
The predicate of that is that this is not a tort actionable per se in the statutory variant of the tort. And
well, it's a consequence of that.
So, my Lord, just to be clear, because maybe I can tailor my submissions, but is your Lordship's point that the Parliament has created a tort actionable per se?
No, my point is that what I understand the appellant to be saying is that the second route, or that the second route, which is the subject of their note, to it not being a tort actionable per se, but to being a tort where financial loss remains the gist of the tort, is the fact that it says nothing about what the defendant may not prove, may or may not prove. It at best creates a rebuttable presumption. Well, and simply announcing that it creates a tort actionable per se is just to deny the conclusion without any reasons.
Well, my Lord, I feel I need to...
I think we should allow you to develop your submission on why you say it is a tort actionable per se.
I'm grateful, my Lord. So, the way I develop that submission is with reference to Lord Justice Brooke's judgment in the Watkins case. I hope that someone has made available to, particularly to Lord Burroughs' clerk, the decision of the House of Lords, which overruled the decision of the Court of Appeal being that in cases of misfeasance in public office involving a constitutional right, that was a tort actionable per se. That was overruled, so the ratio was overruled by the House of Lords. However, my submission is that the reasoning of Lord Justice Brooke, which led him to that erroneous conclusion, is unaffected, and I'm going to turn up briefly, shortly, a relevant passage in McGregor which supports that. So, my Lords, if we could just look very quickly at the head note. In fact, we don't need to look at the head note because I've just summarised it. So, if we go to paragraph 18 of Lord Justice Brooke's judgment, he says the question at the heart of this appeal is whether proof of damage is a necessary ingredient of the tort of misfeasance in public office. And skipping down to 19, Lord Hobb has explained in Three Rivers how the tort of misfeasance in public office operated in an area left unoccupied because of the limits imposed on the scope of two other classes of tort that involve persons holding public office. One of these is concerned with the invasion of some legally protected right of the plaintiff, such as trespass to the person or to property, and conversion. If the plaintiff's person or some possessory or proprietary right of his is invaded, Lord Hobb has commented such conduct on the part of the defendant is actionable as such, and I don't think I need to read on. Then one goes, my Lords, to paragraph 30 of this judgment, which is the meat of what I seek to extract from this judgment. In the last 300 years, the courts have sometimes had to stop and consider the principles according to which they decide whether a cause of action in tort lies without proof of special damage. Although the general rule was that an action in trespass or conversion lay without proof of damage, and that proof of damage was a prerequisite for an action on the case, like so much in the common law, this general rule was not inviolable. And then he refers to a useful survey of some of the old case law and Mr. Justice Burkitt's judgment, as he then was in Constantine. And Mr. Justice Burkitt extracted from Ashby and White, which is an old chestnut, if I could put it that way. I think I can go down to, if one goes over the page 893 to C in the margin, it said that, on the contrary, from my earliest reading, this is Mr. Justice Burkitt, I've considered it laid up among the very elements of the common law that wherever there is a wrong, there is a remedy to redress it, and that every injury imports damage in the nature of it, and if no other damage is established, the party injured is entitled to a verdict for nominal damages. And then one can go to paragraph 44. And this is Lord Justice Brooks' conclusions on the law, having reviewed those cases. What all these cases tell us is that, as Lord Hophouse said in Three Rivers, the common law has always shown itself jealous to protect possessory or proprietary rights, or the rights protected by the tort of trespass to the person. In those cases, a cause of action arises if the right is infringed without any need to prove special damage or some mental element on the infringer's part, such as malicious intent or awareness of the infringement coupled with recklessness as to its consequences. The rationale behind an award of nominal damages in these cases was explained by Lord Halsbury in the Medina. Nominal damages is a technical phrase which means that you have negated anything like real damage, but that you are affirming by your nominal damages that there is an infraction of a legal right, which, though it gives you no right to any real damages at all, yet gives you a right to the verdict or judgment because your legal right has been infringed. There are also cases which don't fall within such a tidy category, but which owe their origin to the way a particular tort developed long ago in our legal history. A good example is defamation by the written word, where a claimant may recover nominal damages for the infringement of his right to a fair reputation, a right not protected by the law of trespass to the person, without any need to prove special damage. The difficulties of categorization in borderline cases is illustrated by the 3-2 split in the maintenance case of Neville. And I don't think I need to read the next paragraph. So, my Lord, the court's conclusion in the instant case, then, is at 51 to 52 on this specific tort. We've already seen it in the head note, but I mean the ratio is that because it's a constitutional right, then it should be actionable without proof of special damage. Now, the point I'm trying to make here is, I think, because it came up earlier in argument, that actionable per se is not specific. It's not about reputational damage. Although libel is an example of a tort actionable per se, and slander actionable per se is another, it's a broader principle than that. It's really to do with causes of action where either the common law or Parliament has decided that this is a situation in which the court should give remedies, automatic remedies, you might say, because of the nature of the tort. And I think my Lord Burrows referred to yesterday to breach of contract falling into that category as well. And in fact, we'll see that in a moment in McGregor. So my Lords, having dealt with that, in my submission, in the case of torts actionable per se, as we've seen, there's nothing inherently deficient or objectionable where the other elements of the tort are satisfied and a claim being upheld and judgment being entered for the claimant for an award of nominal damages. I'm not going to turn it up, but I mean, we make that submission at paragraph 41 of our written case, and that's in the core volume at page 120. But if you'll permit me, what I am going to turn up is page 1850 of the core volumes, which is the relevant passage from McGregor. Your Lordships will bear with me, yes. So it's this is the account of nominal damages.
Just give me the page again.
I'm sorry, my Lord, it's page 1850. So this goes to my point that there is nothing inherently objectionable or deficient about an award for nominal damages in a case where the claim is actionable per se.
I don't understand that to be in dispute. The point is whether this is a claim actionable per se or not. That's what all the argument's about.
Well, my Lord's had my argument apropos of the appellant's note, and obviously Mr. Bennett's addressed that too. So, I mean, if you've heard that argument, there is no point in me pushing further. But can I just...
Accepted, if it's actionable per se, you're entitled to nominal damages.
All right. Just for your Lordship's note, or particularly Lord Burrows' note, if one looks at the very end of 12002 on page 1580, the discussion which I've taken your Lordships to in Watkins is a discussion which, according to McGregor, is unaffected by the Court of Appeal's holding in favour of actionability per se being reversed by the House of Lords. So I'm not going to turn up the House of Lords judgment because I subscribe to that.
Thank you.
So, my lords, in the instant case, turning to the instant case, Miss George, we say, would have been entitled to an award of substantial general damages to compensate her for the pecuniary damage she is likely to have been found to have suffered as a result of Miss Cannell's falsehoods.
So could you say that this is your summary? Could you say it a bit more slowly, please?
I'm sorry, my lord. In the instant case, Miss George, the claimant, would have been entitled to an award of substantial general damages to compensate her for the pecuniary damage she is likely to have been found to have suffered as a result of Miss Cannell's falsehoods, e.g., in the form narrowly of loss of commission, and or, as we saw in the Caradapas case, more broadly, damage to her commercial, professional prospects in her marketplace. Had it not been for the fact that she acted idiosyncratically to the situation that presented itself so as to deprive herself of such an award, as the judge found, specifically her decision voluntarily to resign from her employment rather than try to soldier on. And the reference for your note is Mr. Justice Saini's judgment at 181 to 182, and that's in the core volume at page 215. So with that said, in my submission, as a matter of law, as per the account in McGregor on nominal damages, in my submission, it does not follow from the fact that Miss George has not established an entitlement to anything more than award of nominal pecuniary damages, that she should be deprived of the judgment in her favour, or the value of that judgment for her, in terms of its public, declaratory, and vindicatory effect. It clears her name, it nails the lie. The primary interest in my submission, protected by the law of malicious falsehood in all its forms, is an economic one, primarily. But the Court of Appeal, both in Joyce and in Caradapas, spoke also of clearing one's name as an interest properly protectable by a claim for malicious falsehood. So, my lords, if this is all correct...
Which was the case that you...
I'm so sorry. So the two cases are Joyce, which we looked at, and the other one is Caradapas.
Oh, yes.
That's the one we looked at earlier.
Yes, the two Court of Appeal cases, which of course we place strong reliance on. So, my lords, if this is all so far correct, and I appreciate my Lord Legate is indicating it may not be, but let's assume it is, it is submitted that there is no reason in principle, as Lord Justice Warby concluded at paragraph 78 of his judgment, and that's well, we should look at it. So it's core volume, page 174, my lords. And actually, may I just invite your lordships to read that? I mean, the relevant bit is about halfway in, but...
So which paragraph?
Sorry, which paragraph?
78. So what I derive from that is, obviously, if it is accepted that what has been created by Section 3 is a tort actionable per se, and everything else I've said is correct, that if the award for the pecuniary element of general damages are nominal, as opposed to substantial, the claimant should not be. There's no reason why the claimant should not be able to recover due compensation for the distress and injury to feelings she foreseeably suffered as a result of Miss Cannell's dishonest publications concerning her and the way in which Miss Cannell opted to conduct her defence at trial. Whether you call them general or aggravated damages in my submission is simply semantics. It doesn't matter, and often there's an elision between the two. And in my submission, that would be the fair and just result. On the latter point, Mr. Bennett has already referred to Mr. Justice Saini's use of the phrase character assassination. The paragraph for your note is paragraph 14 in Mr. Justice Saini's judgment, which is at page 184 in the core volumes. In parenthesis, there may be other cases of malicious falsehood or of other torts actionable per se, where an award of nominal damages might properly be coupled with a final injunction. And one remembers the sort of old case from law school of the person who's stolen someone else's horse, has ridden it, he's stolen it, but he's ridden it, and the horse is actually in better condition than when it was stolen. Now, even in that scenario, although there's been no damage suffered, the claimant's entitled to judgment in his or her favour, and in appropriate circumstances, an injunction to prevent further conversion of the horse. And of course, conversion, as I've mentioned, is a tort actionable per se. So, in short, my lords, as submitted in our response to the appellant's note, which is our responses in the supplemental bundle at page 276, the argument advanced in the appellant's note rests on a fundamentally unsound foundation, but for additional reasons which only emerged as a result of listening to Mr. Price's oral submissions yesterday. Beyond what I've just had to say, the court is simply respectfully invited to read our response at its leisure. So, my lords, unless there's anything else I can help you with, those are my submissions.
Mr. Busuttil, Mr. Bennett, thank you very much. Mr. Price.
My lords, I wanted to cover briefly, I think it's 11 topics in reply. I'm just going to go through them. Firstly, we now know this is a radical departure to settled practice and understandings of actionable per se in economic torts. Secondly, the idea that it's going to make everything easier, Mr. Bennett said. Thirdly, the references to proving actual pecuniary loss. We see that in the Porter report and elsewhere, and what that...
Sorry, slow down a bit if you could. Okay. What was your third point, please?
Proving the references to proving actual pecuniary loss in Porter and elsewhere, and that this is a different concept from inferring probably that some financial loss has taken place. So when there's a reference to avoiding a need to prove financial loss, that doesn't mean that you can get away without some likelihood that financial loss has been...
Are you adopting the technique of telling us what all 11 points are going to be and telling us the 11 points?
I know, I think that was a mistake. I was trying to work, I didn't want to make the court think I was going to be going on for a long time, but shall I mention them all? I'm going to get into them. Perhaps it's best if I just start, and if I may, and...
The trouble with giving a summary,
yes,
it may provoke questions from my colleagues, which will drive you into the submission itself.
It's the wrong direction. Okay.
You will note that you've got 11 points to make, and
yes.
if you let us know when you move from one to the other,
yes, I will. So the
that
first
will be
one,
an adequate guide.
Okay. First one, it's a radical departure. We can just see that, because in the Court of Appeal, cases like Tesla were sort of explained away and didn't really confront its obvious inconsistency with the, I'm still calling it the tendency test as opposed to the inherently likely test, because of its inability to take into account competing causes, as one would ordinarily do in civil litigation on liability. So that is a big departure. I took you through Tesla, I took you through Tinkler. Sallows, it's not just a question of having the wrong tense. It's conceptually, the tendency test can't take into account the compensation for wrongful dismissal as being a relevant factor on Section 3 because it's extrinsic. That's the problem that Lord Justice Warby had, and that's perhaps why he got the tense wrong. But it's more fundamental than that. I didn't go to the textbooks in their current form because they're set out in the case, but I think I should just directly refer the court to them if I may. They're on page 85 of the bundle. And so that's from my case, starting at paragraph 89. And they really are fairly explicit in terms of the admission of competing causes, and they are long-standing. Gatley, absolutely clear. You can see that paragraph 90. So this applies to special damages or section 3. Defendant will not be liable where the damage is attributable not to his words, but some other unconnected fact or circumstance. Now, we've all been proceeding on that basis for a very long time. And we're being told now that we've got to depart from it in a very radical way. Next, McGregor. This first sentence, as I mentioned, was in the 1961 edition, confirming that pecuniary loss remains the gist of the tort. Quite clear that all that Section 3 is doing is removing the need to prove specific pecuniary loss. And it's a point that my Lord Legate was making in response to submissions of Mr. Bennett. There's a distinction there between special damage and pecuniary damage, so it's clearly retaining pecuniary loss as founding the tort. And then what's been added since Sallows and Griffiths in every single edition is that Sallows and Griffiths provides confirmation of this. This view now obtains positive support from Sallows and Griffiths, where no damage to malicious forces were awarded as there was a failure to show pecuniary loss. And then similar statement in Clark and Linsell, confirming all the authorities that I went through. My learned friend didn't really deal with the problem of truthful statements within a publication. Obviously, that is a particular concern to media defence, because often there's a number of allegations published, and if the claimant can simply hone in on one, that's a real slap tactic. Let's pick the one that's false, and let's just put all the focus on that. And if you're not allowed to turn around and say, well, hang on a minute, there's a whole lot of other things in this article which are true, which had the same effect, then you've lost a valuable free speech protection. And there was simply no engagement with that by my learned friend, because it can't be reconciled with the tendency test. The tendency test cannot take into account the truth of imputations not complained of.
So, in short, your point is that the 3 Court of Appeal cases on which you rely and the 3 textbooks are inconsistent with the respondent's case.
Yes, and that's become crystal clear for the first time today, because it's sort of slightly fudged by the Court of Appeal with respect in the present case and in the respondent's case.
Yeah, thank you.
The notion this is going to make things easier is rather strange, because...
This is your second point, is it?
Yeah, second point. Oh, forgive me. Yeah, second point, the idea it's going to make things easier. It's accepted from a learned friend that all the same facts that I say should be taken account in relation to Section 3 must be taken account in relation to damages, which is a historic test at the date of trial. So it just creates a complication. Not only that, in terms of Jamil, which learned friends accept is a runner, anything can go in on Jamil. It can all come back in on Jamil. So it's all there already, possibly at an interim hearing. I mean, why not just deal with it in the way that it ought to be dealt with, which is a historic test at trial on the basis of whether financial loss is likely to be caused. The next topic is the references we see frequently to proving actual pecuniary loss, and that Section 3 relieves a claimant from doing so. Just to remind the court that I went through Radcliffe and Evans and those cases showing how actual loss was used as another way of saying special damage. So, I mean, there's two elements to it. It's the proving and it's the actual. The actual is a way of signifying special. I think my Lord Burrows referred to a reference to prove that actual pecuniary loss has been caused in paragraph 33 of the Porter report, and I would say that that's another example of a reference to special damage. It's not intending to rule out of the determination at trial whether any financial loss has been caused. And I would also respectfully submit that we are here to interpret Section 3, not the Porter report. And one of the reasons for the exclusionary rules that we have in this regard is that the tail doesn't end up wagging the dog. I mean, the report's admissible to identify the mischief, and that clearly helps my client's case because the mischief is merely helping a claimant where loss has been caused. Proving actual loss is different from inferring the likelihood of some loss having been caused. That's what I accept a claimant can now do. This claimant can't, but a claimant can now do. And that's a gain, and it absolutely addresses the mischief. Next, the references.
Do you take any distinction between inferring and presuming?
Well, I suppose a presumption is often described as an inference. I suppose the difference is to what level of the facts that one goes into. My primary submission is that the effect of Section 3 is to allow a claimant to infer financial loss. And the inquiry is all within the confines of Section 3 on the damage element of malicious falsehood. It's a historic test at trial. But if I'm wrong, the second point that's raised in the appellant's notice a month ago, not a week ago, and you've got the response of the respondent to that notice, is that I think I said it was a presumption or inference. I think probably correctly it would be a presumption. But I mean, it's not straightforward because you'd also, if it was a presumption, you'd have to sort of work out what triggered the presumption. And then one comes back to the point made by my Lord Hamlin to me and to then friend Mr. Bennett about exactly what's the ambit of the context and circumstances of publication, which is accepted, the Court of Appeal said, should be taken into account before determining whether you're in Section 3 territory. If it operates as a presumption, you still have to define clearly when the presumption arises and what the correct test would be for the, obviously trial judges in malicious falsehood claims are going to have to decide them on the basis of this court's.
You're not particularly concerned, I don't think, in this case to determine when the inference or presumption can be taken. Your interest is to say that even if there is an inference or a presumption, the defendant can still, on the question of liability, lead evidence on causation.
Yes.
That's the nub, isn't it?
That's the nub of it, yeah. And forgive my Lord Burrows, I'm not perhaps in a position to give a definitive answer as to the difference between a presumption or an inference. I mean, the main thing is that...
I can't see any difference if the presumption is rebuttable, because yes. One thing if it's a legal presumption where you have to treat something as true, but if it's simply what's called a rebuttable presumption, yes. I don't see any difference between that and an inference.
Yes. No. The next area is the reference to inherent probability in paragraph 27 of the Court of Appeal's judgment that my Lord Richards ask some questions of Mr. Bennett about it in the context of a likely verification by the publishee. And with respect to Mr. Bennett, I don't think a satisfactory answer came out. I mean, the purpose of using the word inherently likely is simply to limit either the relevant facts that can be taken into account or how far in practice you look forward to what the publishee is likely in practice to do, or whether you just work on the basis that the publishee will assume it to be true. And I don't really have a clear-cut answer, because it's not my case that the law works in this way with a limitation of inherently likely. But it's one of the reasons why it shouldn't do, because the obvious question, if you're going to adopt a forward-looking test from the date of publication, is what will this publishee, or what is it likely that this publishee will do? And that's the way that those cases which have put forward the Section 3 test on a forward-looking basis have approached it. And I mean, this would be an argument, I say, available to me on the facts of this case, but I've got a more fundamental argument, which is that Butler didn't want to do business with her, and Lingerfelder had already told her not to solicit the second appellant's clients for reasons unconnected with any restriction in her contract. So I can't give an answer, but it just shows why we shouldn't be adopting this test, because it's artificial and creates unnecessary difficulties. Next, related to that, is the Sir Alex Ferguson gloss, which is not a football tactic. I think what it is that the approach should not be one of mere possibility. It should be more likely than not. I think that's what Lord Justice Warby was referring to when he talked about the Ferguson gloss. Next is the concept of a statutory tort of slander. I mean, there were some pretty big legal concepts that were raised by my learned friend Mr. Basutil, ostensibly in response to a statement in the appellant's note of last month saying the financial loss remains the gist of the tort, which had been the core case of the appellants right from the very start and was the main item in the appellant's case. But since it's been raised, the effect of, I mean, certain slanders were actionable per se already in common law, and the effect of Section 2 is just to remove a requirement for special damage, which will necessarily lead to it being actionable per se. The point being that economic torts were not actionable per se. So it's really, it doesn't assist. The next and related point is my friend's reliance on Watkins. Well, Watkins was a situation where, as I understand it, there was uncertainty in the common law about whether a tort was actionable per se, and therefore the court had perhaps a choice in the matter and decided that misfeasance in public office should be actionable per se, but the reasoning for that was that it interfered with a constitutional right. So immediately you have a breach of a right, then there's an entitlement to nominal damages. I mean, I could make a case that nominal damages are just unnecessary and archaic, but there's no need for me to do so. And we've got a very different situation here, which we have a common law position where loss is the gist of economic torts, whether it's special damage or whether it's the inducement to breach of contract. You can infer damage. And you're being asked to jettison that common law principle. And the way that things normally work there is that you only do so when it's very clear that that's what Parliament was intending. But in fact, it's absolutely clear that Parliament was intending not to do so because of its juxtaposition of special damage and pecuniary damage. The final submission of Mr. Basutil was along the lines of there would have been substantial damage for the likelihood of loss. and then there should be some compensation for vindication. I mean, I didn't. Those are quite big concepts, and with respect, not very coherent. Vindication is not irrelevant. I mean, vindication is related to reputation, and the protection of reputation is not an interest that's protected by this tort. It's a tort for financial loss. One can't bring in vindication as justifying the tort. What happened in Joyce and Sem Gupta is that the claimant had a perfectly respectable case of economic loss, and the suggestion was that she shouldn't be allowed to pursue it because in reality it was a libel case, and the court accepted that she was entitled to have the purpose, her subjective purpose in bringing it could cover her wish for vindication. It didn't say that that was the interest protected by the tort, or that such damages would be available for vindication in the event that she established the necessary elements of the tort. In fact, in that passage that we looked at twice now, Sir Donald Nichols makes clear the difficulties of extracting reputational concerns, interests from financial loss, and the need to be coherent.
So the reference to clearing the name, you say that's relating to reputational matters, do you? Or what?
Yeah, I mean, clearing her name would suggest that that's reputational, but the context was, should she be allowed to proceed with the claim? Is it an abusive process? She had a perfectly respectable argument that she suffered loss. If there was no, I'm sure that the logic would be, and I'm sure that Sir Donald Nichols would follow the logic, if she had no case at all, the publication was likely to cause her financial loss, had caused her financial loss, whether you take a forward-looking or historic test, that she could continue with the claim to be vindicated. That would not work. The context here is an allegation in a national newspaper that's making defamatory allegations about her and her conduct as a housemaid to the royal family, which are defamatory, but also are liable to cause her financial loss. And I don't think one can read into references to her being entitled to continue with the claim, to clear her name, as a finding that if you succeed in malicious falsehood, you can get an element of damages for vindication as well. Bear in mind that vindicatory damages are hard to reconcile with the basic compensatory rule because they put you in a better position. And I come back to my overriding point about this is a tort which everyone accepts is solely to protect economic interests. If your economic interest has been affected and you're upset by it, well, one can see a principal basis for an additional recovery, or if there's been bad behaviour in the conduct of the litigation. That's all conventional stuff. Quinn and Leatham, Pratt, those turn-of-the-century cases involving blacklists. But I don't think one can read into that any notion that you can get vindicatory damages for malicious falsehood. And I think the more correct approach is to keep to recognise the differences between the torts, the points that were made by Lord Sumption in the show about their very different nature. And also, of course, the other context is that Parliament has set a serious harm hurdle in defamation.
Yes, I'm not sure it was being suggested that you get vindicatory damages. I think the argument was you're entitled to nominal damages which serve the purpose of vindication.
But then they're not increased for any vindicatory element. I mean, the judge's finding serves the purpose of vindication. One of the reasons why nominal damages are kind of strange is you couldn't have a declaration. I mean, that wouldn't just, you couldn't bring you'd be able to bring a malicious falsehood claim to get a declaration that the statement was false and maliciously made. I mean, that would open the doors very widely, and that was the point that was made by Lord Herschel in White and Melling, that what people are trying to do here is get a judicial determination that their product is better than their competitors. This tort has to be kept within its proper bounds. That was the mood music in the Victorian era, and it's much more than mood music here when we have Article 10 to take into account, and we have a need to allocate resources in a proportionate manner. Next, I've probably covered it, is that there are a large number of reasons against making a tort, and in particular this tort, actionable per se, given its breadth, given the engagement of Article 10, given the other means of protecting, of dealing with falsehoods. I've got 3 more subjects, which are Article 10, distress, and the respondent's notice. On Article 10,
when you say plenty of other means of dealing with falsehoods, what have you got in mind?
defamation, data protection,
I see.
they're the main ones. I mean, data protection is extremely wide.
But none that would deal with this falsehood.
I'm sorry, Lord?
None that would deal with the falsehood in this particular case.
Well, it would do, because it's defamatory. But
If it's defamatory.
it is defamatory. Right. But Parliament has set a harm hurdle that it can't surmount for reasons of policy and taking into account Article 10. So I think I'm entitled to pray and aid the availability of defamation as one of the reasons to keep malicious falsehood within its proper bounds. And data protection, of course, would well, I think it would probably protect the email would be covered by it, maybe not the conversation. But we're looking things not just on the facts of this case, but just generally at the free speech environment and where malicious falsehood falls within it. And by free speech environment, I mean not only the impact on free speech, but the ability to protect the rights of the claimant. My old friend makes a point that's always made in relation to Article 10, well, there's no public interest in misinformation. And this submission focuses on the falsity element, because the public interest is concerned with the misinformation. It doesn't matter whether it's maliciously made or not. The idea is that you give false information about a product, someone decides not to buy it when perhaps they ought to, and that's not in the public interest. I mean, the chilling argument, of course, proceeds on this basis. It's perhaps stated best in the Sullivan case in the US Supreme Court, and I'll just read it because it's a classic.
Which case, sorry?
Sullivan, Sullivan, New York Times.
Have we got that?
No, but I mean, it's just a very general statement of principle. I mean, that is the leading case on freedom of expression. I can provide it, but it's this: that erroneous statement is inevitable in free debate, and that it must be protected if the freedoms of expression are to have the breathing space that they need to survive. So it's that concept of breathing space. If you tie speech up in regulation and the sanction too greatly, you chill free speech. And that's the whole basis on which chilling effect has proceeded.
It's one thing to make a mistake. It's another thing to make a dishonest and deliberate mistake.
Well, I will come on to that, but if I may just take it in stages, because the public interest is in the misinformation.
The
Public interest, the case that it's not, the argument on public interest, why you restrict speech, is because there's no public interest in misinformation. That's how the public interest is harmed, by the publication of misinformation. That's the argument.
Yes.
I think the argument I think the respondent's argument went beyond that. I think they were saying there was no public information in the dissemination maliciously of lies.
Well, I'm coming on to the maliciously.
No, but I don't think it's confined to misinformation.
Yes. No. I mean, as I say, I'm trying to take it in stages, because I think it is important when these free speech concepts, they sound a sort of bit, oh yeah, Article 10, free speech, but you do need to sort of drill them down, because Section 3 requires the court to take this in. Section 3 of the Human Rights Act requires the court to take into account Article 10 in its interpretive role. And it's clear that Article 10 is engaged, and there is existing case law based on Article 10, which says that you need to keep this tort within proper bounds, and there's been a specific aspect of Section 3 of the 1952 Act that has been interpreted in the light of Article 10, which is the Ferguson gloss, that it's not a mere prospect, it's got to be more likely than not. So it's very much in play in this interpretation. Of course, I only need it if I don't succeed on conventional grounds. But the public interest, the problem in terms of public interest relates to misinformation. And my general point is that you have to give some breathing space to misinformation, otherwise you end up chilling correct information. Malice, the requirement to prove malice is really the only thing that's being advanced now as an answer to the chilling effect, the point that my Lord Hodge made, that the availability of this action is likely to result, apologies if I've mischaracterised this, but is likely to result in people using it, trying to stop speech. That's undoubtedly going to happen, is already happening. I don't need to go any further than the observation in the recent edition of Gatley that a major tactical advantage of malicious falsehood is that there's no serious harm requirement. Now, that tactical advantage has been hugely, or will be, hugely increased if it's actionable per se. The reference to Gatley is page 1808. So one can assume that people are going to, if this tort is actionable per se, people are going to use it as a way of trying to stop speech or sanctioning people. So then you have to ask yourself, well, what stands in the way of that? And what we're being told is standing in the way of that is a requirement to prove malice.
The breathing space you referred to in Sullivan didn't extend to malice, did it? Because that case decided, if I recall, that you had to prove actual malice in order to succeed in a defamation claim against a public figure.
Yes.
So they didn't record that latitude where malice was shown.
No, but there are, as was, I think we've got the case of Ajinomoto within the bundle, but there are a number of ways in which Article 10 impacts on this tort. One of which, of course, is the requirement to prove malice. That's a factor, I accept. But the other is the harm element. And this tort, if it's actionable per se, will be used to try and seek to chill speech which is truthful or at least honest. That is the reality at the coalface. That is what media defence are saying. And in fact, it's accepted by the Court of Appeal that they say it's unlikely to have a significant chilling effect on honest speech, but they recognise it's going to have some. Media defence say it's going to be more, but the way that the proportionality test works is that even if it's going to have some, this court's got to try and find a way of avoiding it if it possibly can. But I would suggest that getting a case of malice up and running is not that difficult. It just requires a plea of an indifference to truth. There's no requirement to have a motive to injure. There was no allegation of a motive to injure in this case.
Yeah, but counsel on his or her responsibility has to have a basis for saying that there was an indifference to truth.
Yes, but often, I mean, the statement was false. You should have looked at this. You could have done that. I mean, it's my submission. I understand there's a responsibility, but that's no different from any serious allegation. There's a responsibility, but you see,
it's not that difficult to prove to allege that you've suffered some financial loss, relying on the presumption, even if you haven't.
Yeah, we're dealing with proportionality selections, and the selection that's being made now, partly reflecting who I'm acting for, and the primary facts that have been found, is that there should be at least a requirement that some financial loss has been caused. I haven't gone beyond that, but that does at least provide some measure to free speech, and I haven't pushed to go further than that. But the question is, do you tie it up even more? Do you make it actionable per se, which would be very easy? I mean, this would be a finding from this court that there has to be financial loss would be of material benefit to the media, because there's huge numbers of situations in which these arise. I mean, it's said that Tesla is somehow idiosyncratic. Repeat publications are going on all the time. There's so much information available. And the opportunity to say, well, you can't infer this has caused you loss because it's been published countless occasions, or for some other reason, to deploy whatever causation argument would be available to you, is a benefit compared to the situation where it's only actionable per se. I mean, the best example my friend could come up with was an actor who's offered 2 years, or a false allegation she's offered 2 years. I mean, obviously, if that was made in a national newspaper and there was, you couldn't run a case that she was a bad actor and then she wasn't going to get any instructions. I mean, if she's had a career as an actor, this would be likely, the inferential case would succeed. But there's lots of situations where the inferential case would not succeed, and therefore a requirement for there to be financial loss, or be it inferred, would be of assistance. And if you're deciding between different interpretations, you should go for the one which is most pro-free speech, unless there's an engagement of a right of a claimant, because free speech is a trump card if there's no engagement from a right of a claimant, and there's been no suggestion there is an engagement of a right of a claimant. So you have to be going as far as you can in the direction of free speech until you hit a right of a claimant. And the case that I'm putting forward doesn't hit a right of a claimant. So, whereas the case that's being put forward on behalf of the respondent clearly hits free speech. So we come back to the malice hurdle, the need to allege it. I simply refer to the cases that are in the bundle where malice has been found, where malice has been alleged, the basis of it. I mean, the BBC case, for example, they just wanted to do a sensational programme. That's always put forward in media cases. They were just trying to sensationalise. The car actually didn't stop in this way, it stopped in another way. And the BBC strike application did not extend to malice. It was specifically stated in the judgment. That had to be a triable issue. You had to cross-examine the presenters of the programme, you had to go through the whole rigmarole. And what they had was a way out based on Section 3, and that would be of use to have that way out. And malice is insufficient, because you can't. It's also the question of the chilling effect is also just at the post-publication stage, pre-litigation stage, where is a lawyer going to turn around and say, well, they're never going to get a case of malice up and running? No lawyer is ever going to say that. It's not how things work in the real world. It's not a substitute. The hurdles of proving malice or pleading malice are really not a substitute for a Article 10 compliant damage hurdle. And so
Lord Justice Warby thought it would be a pretty rare case where, in fact, there was no loss.
I think that,
Would you take issue with that?
well, that's a different point. That's not on malice. That's
No, but it goes to your Article 10.
yes, absolutely, of course. So what he's saying is that it's a rare case where an allegation would have an inherent tendency to cause loss, but there's no loss or inherent likelihood.
Yes. I mean, the sort of cases one can imagine where claimants would try and prevent publication or sue on it. The sort of cases where you would imagine there would prima facie, at any rate, probably be economic loss.
Well, not necessarily.
Not necessarily.
But in terms
This
of
goes to how effective. I mean, I understand your submission entirely. I think the only point is how effective is this at
Screening out cases.
Yes, exactly.
well, it would be. I mean, it has been
It would
used
be
to spring
here.
out cases.
It would
I mean,
be here.
it sprung
Well, it
out
wouldn't be here. It had to go to trial
Well,
to
it did.
decide whether there had been a loss or not.
on this case, but this is well, probably not. I think actually no. This case went to trial because of the suggestion that it had been published throughout the industry. I mean, if it had been limited to those two publications, you probably could have done it on a strikeout basis with the...
No, but it went to trial on that issue. I mean,
It did have to
so
go
it
to
did
trial,
go to trial on that.
Oh, yes, obviously, it did go to trial on that issue. But
I mean, all I'm suggesting is that, although I see the point you're making, I think it's not going to provide a very great protection for Article 10 freedom of speech, because it's going to arise sort of not very often at a stage where you can just say, well, we can't bring the proceedings.
well, with respect, no, because of the disconnect between the tendency test and the reality of loss, as been illustrated by the cases. I deal with this in on page 74 of which is paragraph 44. 44.2 of our case, head on. If I can, 44.23 is really important. That's specifically highlighted by media defence. It's the presence of true allegations within the article as a whole, but they're not complained of. It's also important to bear in mind that the tendency test can apply to publication to one person. If my Lord asked me whether it's rare, all I can do is draw on my 1060 on Monday, my 35-year experience of litigating media claims, which...
Well, you're not allowed to do that,
No.
Lord Justice Warby did it as a judge, I think.
Let me say this as a general matter. If you allow a publication where there's no real loss to be the subject of a claim, it must necessarily be open to some form of abuse for us, which you can't actually necessarily prove as a dominant and proper motive to have the claim struck out. But it can be used on a sort of CFA-driven litigation to try and get some costs. Just a tactical use of litigation, which in my submission, one sees in the commercial cases, that you've got a very serious claim against you, and you throw in a counterclaim. I mean, that's not so much Article 10 related, but let's put my experience to one side. That the cases that I've cited, every principle that's in the case is in the appellant's case is backed up by authority, and the authority suggests that people will go where the tactical advantage is. That's the way the litigation works, and I suppose I don't really need to add anything more than what, in my respectful submission, has been said cogently by media defence as to the likely outcome. But anyway, in a sense, it doesn't really matter how much of a chilling effect it's going to have. It needs to be avoided, because it's not proportionate to allow any chilling effect unless there's a right engaged to the claimant. We don't have a balancing exercise where you might want to take into account malice as being irrelevant, because malice is an element of the claim. If I was to turn around and say, actually, you can't bring a malicious falsehood claim unless you show substantial damage, for example. Then you might want to put into the mix in determining that, well, a requirement is malice. So I'm here between a claimant who's suffered some damage but not substantial and a defendant who's been malicious. But there'd be a balance to be weighed, and the malice would weigh perhaps heavily. But here, we're not dealing with anything else in the scales, because there's no right engaged and no suggestion at any point that right has been engaged. And the respondent hasn't picked up the suggestion of a protection of health and morals, which we saw in the Court of Appeal's judgment, which is not a runner for the reasons that I've given. So free speech is the trump card in this case, and that applies also on a micro basis. My client's Article 10 rights are engaged in this case just as much as Monsieur Tet's were in Tet and France. It wasn't only that case involved a matter of public interest. That's not the only factor. That just weighs in the balance, because it's accepted that commercial speech has some protection under Article 10. These publications are, in principle, protected by Article 10. The only issue arises if there's a balance with the claimant's right. So there's no justification under Article 10 for a finding of liability and, more relevantly, a £2 million costs order against her arising from it, potentially.
Well, that's what the argument in this appeal is all about, presumably, the costs.
Yeah. I mean, I can't go... I mean, we'll have to consider that further when we get to costs, because I'm constrained in what I can say, but...
I mean, they're not here because of the difference between nominal damages and no damages at all.
We're here because we won at trial, and there was a decision at that stage for the respondent to appeal to the Court of Appeal. Then we lost in the Court of Appeal. That's why we're here, because we lost in the Court of Appeal. We won at trial, and then we're here as a consequence of that. But I mean, I can't...
Because you had to pay all the costs as a result of losing... the other way around, sorry. The cost orders got reversed by the Court of Appeal.
It hasn't got reversed, because, I mean, we won on defamation. I mean, right. Actually, as it happened, the trial judge gave us all our costs. I mean, because there was an argument we were found to be malicious, we lost on issues, but... Well,
I don't think this is the time to be addressing costs.
Yes, well, let's not worry about that. But I mean, that's the costs are the problem in media litigation. That's the reality. That's the chilling factor. The chilling factor arises from the costs. We all know that. And that's what Parliament recognised when passing the Act. There's a massive disproportionality that this legal system permits at the moment between what's at stake and the cost of litigating it when it comes to media cases.
That's the point made by the intervener.
Yeah. So, on a micro level, there's no justification for a finding of liability against my client, because there's no right that's been infringed, and the malice is not doesn't stop her from relying on that. This next subject is distress, and Joyce, just briefly, need to make some submissions on that in the light of the submissions that were made. We'd only be here if a risk of harm was sufficient to found liability. We wouldn't be considering damages. And to allow liability with a risk of harm is, in my submission, contrary to principle and incoherent for all the reasons that I've submitted. But to add to that, distress damages for the risk of harm, when there's been no loss, would be even further incoherent, even further contrary to principle. And the nature of this tort, which is an economic tort, to give compensation for financial loss. I cited those general principles in the case about the absence of authority where a court has given distress damages where they haven't been related to a loss that's recognised by the particular tort, or where compensation for distress isn't part of the particular tort. No authority has been put forward, and Joyce is certainly not authority for that. Joyce reflects the orthodoxy that the damages may be available where there's material loss. I mean, that's throughout the judgment. I don't need to go to it for a third time, but every single reference to the availability of damages is on the basis of there having been some loss. And then if I may end where I started, which is the 3 facts, because it just wants to be, in light of what my learned friend has said about them being sort of raised belatedly and not really being before the judge at trial, etc., and the consequence was, of the Lingerfelder email, was a ring fencing of clients. I think it's important that the court should see what's in the respondent's notice, which is in the supplemental bundle at page 265, because it couldn't be clearer.
Page
265, but this is a supplemental bundle.
yes.
What you have here is the relevant part of the respondent's notice, which has been extracted because the respondent's notice which follows is, the typing's quite small. So if you look at...
So when was this document launched?
This was put in within time in the process of the appeal to the Court of Appeal. So it was before the Court of Appeal. It complied with all the rules. And the case it makes is that if the test is forward-looking from the date of publication, you take into account all probative circumstances on the likelihood of loss, and then the only rational conclusion, it doesn't need another finding from the trial judge, the only rational conclusion is that the Butler words and the Lingerfelder email were not likely to cause such loss. I mean, Butler is set out at 2, the obvious point that he'd already decided not to do business with her, so at the time that was pre-publication. And then in relation to Lingerfelder, there's my second big fact, the first one with Lingerfelder at 3.1. Mr. Lingerfelder had never wanted the claimant to deal with the second defendant's clients and had warned her against doing so, not because of any alleged contractual restraints at the start of her employment. So the way that, even on my learned friend's case, it's got to work is that the falsehood is the existence breach of non-solicitation clause. That prompts an employer to turn around who would otherwise want business with the employee's former employer, but because of what's been said, he says, no, you've got to stop. Well, my learned friend referred to the post-publication, no, you've got to stop, as somehow sort of a point that he could have used had it been a historic test. But clearly, you've got to ring fence the clients is simply consistent with what he said at the beginning, which is you don't want you to be dealing with them. That's the primary fact that the respondent is stuck with, whether she likes it or not. And then it continues with the obvious ascertainment of falsity on the part of Mr. Lingerfelder, because there's the email at 16:30 from the first appellant to the respondent saying, I'm going to write to your employer. The fact that the respondent had the handbook with her at the time, and that it demonstrated there were no post-employment restrictions, which I think is accepted, and that she went to find Mr. Lingerfelder immediately on receiving the email. So it doesn't really matter exactly when he read it, but where she was, or whether she'd arrived or anything. I mean, on a forward-looking test, which takes into account only facts in existence at the time of publication, there was no likelihood of loss for the independent reason that he was about to find out that the allegation was untrue, which is, of course, what happened. So, unless I could be any further assistance, those are my submissions in reply.
Mr. Price, thank you very much. It only remains for me to thank counsel for their careful submissions in this case, which raises a significant point of law. It is unfortunate that 2 individuals have found themselves in this unfortunate dispute coming all the way to this court, but that's how things are. Our thanks also go to those who have assisted Council in preparing their submissions and in preparing the documents for this case. The court will produce a judgment as soon as it reasonably can, and will now adjourn.